Chair, I can confirm that the recording and the live stream has started.
Thank you. Okay, everyone, welcome back to this meeting of the Licensing Board. Thank you for those that have been waiting a long time to get to your items. We'll move through them now as we can. If I could ask the Deputy Clerk to do a sediment call, please.
Certainly, if members can just confirm they're in attendance when I call out their name. Stuart Adams.
Present.
Miss Dawn Black.
Present.
Jeff Crowson.
Present.
Jeff Goodhall.
Present.
Trevor Mason.
Present.
Richard Menard.
Present.
Jenny Nichol.
Present.
Mel Sullivan.
Here.
And Mr. Taylor.
Present.
Thank you.
Thank you very much. So I would just like to briefly move back to where we left off. I realised that we omitted to clarify the position of the board after the vote had been taken. So I would ask the Deputy Clerk if they could just clarify the decision made by the board, please, for the benefit of the agent.
Certainly. So following the vote, which was 3 votes to 6, the amendment was carried, which was that the board found the grounds for review were established and that a variation was to be made to the licence as follows. The core hours for bar 57 were to be amended to close at 2 AM each day. Specific conditions were to be added to the licence, the first being that the last time of entry to bar 57, including re-entry, would be midnight, including any transfer from the Cali bar. Secondly, that glass drinking receptacles were to be replaced within bar 57 with plastic alternatives, and that was to be in place by the end of the year. And lastly, that door staff within bar 57 were to wear body cameras, and also that this was to be in place before the end of the year. And just to clarify, notwithstanding the above, that no variation to the hours to be granted for Hogmanay, so that would still stand as it was. The decision letter will be issued within 7 days.
Thank you.
Noted, thank you, Your Honours.
Thank you, Mr. McIver. I hope that helps. Okay, so moving on, we now move on to item number 7, which is an application for a major variation of a premises licence, a hearing on the Holiday Inn in West Hill. So can I just confirm that we have got the agents and everyone else that is required in the meeting?
Yes, Your Honours, it's Archie McIver again. Just when you thought you got rid of me, I'm back for this one as well. So.
Not at all, not at all.
So I know that Mr. Diljor, Oshan Diljor, was present for most of the morning. I don't know if he's still here or not.
I am.
Okay, thank you very much for your patience. Can I confirm that the LSO, Lisa Godini, is here?
Yes, I'm here.
Thank you. And can I confirm whether or not the objector, Athol Donaldson, is here?
Yes, and no, we weren't expecting the objector to be joining the call this afternoon, or in fact at any point today. He'd confirmed he wasn't joining. Thank you.
Okay, thank you very much. So if I could then ask the Deputy Clerk to outline the terms of the application and confirm the procedure, please.
Certainly, thank you. So you're presented here today with a report relative to a major variation to the premises licence, which variation includes the addition of an outdoor drinking area for a capacity of 64 persons and a request for on-sale core hours to be extended on a Saturday to 1 AM. Just to confirm, the licence on a Saturday is presently until 12:30 and it already has a 1 AM closure on a Friday. The application requires to be determined by the board following an objection being received from a member of the public. We also received representation from the Licence Standards Officer Lisa Gandini, and as can be seen from Appendix 2, starting at page 162. The matters raised by Ms Gandini have since been resolved. However, she will no doubt confirm her position when she speaks. The objector is not present, nor has he made any further written submissions. Accordingly, members only have the original objection to consider before them today. which can be seen at Appendix 3, starting at page 165. The objection is on the basis that he is of the view the variations being sought are not acceptable in an area of residential development and are detrimental to the well-being of families. I can confirm that the applicant has since agreed to the local conditions recommended, which also includes a condition to the effect that no alcohol can be sold for consumption in the outdoor drinking area after 10 p.m. In terms of the procedure this afternoon, you will hear from the agent for the applicant, who will speak to the application. Then you'll hear from the LSO in terms of her representations. As the objector is not present, we will not hear from the objector. The applicant's agent then will have the opportunity to address any issues raised by the Licensing Standards Officer, and members may then ask questions. The convener will then ask the LSO and the agent, then the agent for the applicant, for any concluding remarks before you will consider the application. Members may of course deliberate and ask for legal advice if required. Thereafter, you are required to confirm if you have sufficient information before we call for a motion or amendment, and any vote if necessary before confirming the position of the board.
Thank you very much, Suzanne. So I would now like to invite the applicant or their agent to outline the terms of your application to the board, and you may wish to address the concerns raised in those representations and objections at this time, although you will get a further opportunity to address the board after the other parties have spoken. Please go ahead.
Right. Thank you, Your Honour. As I say, I'm accompanied by Mr. Dieljoor, who's the operations director for the company which runs the Holiday Inn West, which is the subject of this application, Your Honours. The application for variation, as you've heard, was covered a few bits and pieces. Some of it was merely tidying up the licence, but the two parts which have attracted an objection relate to the outdoor drinking area and also to the 1 AM terminal hour. Now, in his letter of objection, the gentleman makes comment that he is concerned already about noise levels from the hotel. He says it comes mainly from people outside who are drinking and smoking. He's concerned that granting an outdoor licence would increase the numbers of people outside and in so doing increase the current noise levels. He makes a comment about drunk people shouting until well after midnight. Now, if we can just start with that aspect first of all of the objection, Your Honours. The outdoor area, as you have heard, will have a terminal hour of 10 p.m. It's operating and has been for quite some time now on the basis of occasional licences. And to the best of both Mr. Dieljoor's knowledge and the erstwhile day-to-day manager of the premises, no reports of excessive noise have been received to the premises direct from the current objector or anyone else for that matter. And I'm certainly not aware of any official involvement, if I can put it that way, in respect of noise problems or the like. It's, I suppose, a statement of the obvious that the hotel has its own residents, sometimes up to 150 people staying in it. And the last thing that they would wish to do, leaving aside affecting relationships with their neighbours, would be to disturb their own guests who are paying to stay in the hotel overnight, many of whom are there for work and would therefore be getting up early the next morning. So they're very mindful of the question of noise for a whole variety of reasons. There's certainly no awareness of them of any drunken behaviour, if I can put it that way, after midnight. They make the point that the bar is not a particularly busy public bar. The whole area of the premises is covered by CCTV, and they're very well aware of their responsibilities to their neighbours. The outdoor area in question effectively serves the hotel bar and restaurants. So it's generally used for in the main dining and also by in the main hotel guests. It's not a kind of local pub, if I can put it that way. And it's an area that's very carefully monitored. It too is covered by CCTV. So the points raised by the objector as far as the outdoor area is concerned are not ones which the operators recognise. They would certainly not be at all willing to condone any noise being created by persons frequenting the premises. As I say, even from the standpoint of protecting their own guests so that they can enjoy the quietness and have a decent night's sleep. In addition to the CCTV coverage, it goes without saying that being a hotel, the premises overall are monitored 24 hours a day, staff on duty obviously in a 24-hour cycle, including night staff, and firewalks and the like around the interior and exterior of the building are carried out regularly. So even by dint of those walks, any noise nuisance would be easily detected. Significantly, there are no objections from any other of the residents in the area. This is the only adverse comment which has been made. As far as the 1 AM extension is concerned, as your Honours Clerk has alluded to, this would result in a 30-minute extension, and it's really largely to go along with assisting the function business in the hotel. They have maybe 20 weddings a year, other functions on top of that. They have steps in place to control nuisance from anyone who's attending any such function. And generally speaking, the functions in the main cause no issues whatsoever to the outside area. Again, my comments about residents in the hotel applies equally to this. As I say, Your Honours, there are no adverse comments from any of the officials. This is the sole adverse comment, namely the one from the objector. But I would suggest to you that the track record of the premises is such that there is no noise nuisance at the present time of which the operators are aware. Your officials are apparently unaware, given that they have not sought to make comment. And against that background, Your Honours, I'd invite you to grant the application.
Thank you very much, Mr. McIver. If I could now invite the LSO, Lisa Godini, to speak to her representation.
Thank you very much. The Licensing Standards Officer representation related to a query regarding the lower ground floor layout plan as well as recommended local conditions. However, since the board papers were compiled, the query has been resolved and the licence holder is happy to accept the local conditions recommended should the Licensing Board believe them appropriate if this variation application is to be granted. These include conditions relating to general management of the premises, noise, lock-fast storage, duty of care, CCTV and licensed outdoor area. As this hearing relates to concerns relating to a proposed licensed outdoor area, I would like to confirm the outdoor conditions the licence holder has agreed to include the licensed area is not to be used for activities linked to the sale or consumption of alcohol after 10 PM and no amplified music or noise emitted from the use of microphone speakers or any other forms of musical entertainment shall be played within the licensed area. Thank you.
Thank you very much. So I would now ask if Mr. McIver, you have anything you wish to add, having heard the submission from the LSO?
No, thank you, Your Honours.
Thank you. So if I go on to the board members, do you have any questions of either of the parties? Mr. Goodall, Jeff.
Thank you, Chair. Mr. McIver, is there any evidence to show that there is no noise after 10 o'clock? And how long does it take for that area? You probably don't know the answer to this, but how long does it take for that area to be cleared? You know, people come out, they drink at 10 o'clock. Are they away by 11, half 11, 12, whatever?
Certainly, there is no evidence of which the operators are aware that there's noise nuisance after 10 o'clock or indeed before 10 o'clock, Your Honour, emanating from the outside area, which, as I say, has been in use under occasionals for quite some considerable time now. As far as the clearing of the area, if I can put it that way, is concerned, primarily it's used, as I say, for people dining. So really, as soon as the food is finished, the area is tidied up. But if Mr. Dieljo has anything to add to that, I'm more than happy for him to respond.
Yeah, it wouldn't take more than 15 minutes usually for everything to be cleared and packed and closed.
Thank you.
Are you content with that, Mr. Goodall? Yeah. Any other questions? Okay, I'll come in. You've mentioned that you've been operating, or the business has been operating on occasionals in the recent past. Can you specify how long that has actually been for?
It's a bit of a off the top of my head answer to your question, Your Honour, but it must be a ballpark about a year, I would think. Something of that order. I think maybe the LSO might be able to confirm one way or the other.
Yes, I can confirm. I think we go back to July 2023. I think is off the top of my head. It's been running on occasionals.
So this, just to confirm and clarify, this area has been used in the manner in which you're now applying for the permanent variation for the last year, 18 months already, without any complaint.
That's correct, Your Honour, yeah.
Okay, that's great. Thanks very much for that clarification. Anybody else got any questions before we move on? No, I'm seeing no indication. So I would now invite concluding remarks from those that have given evidence, but please bear in mind that you can provide no new evidence. So if I can go to the LSO, Lisa Godini first, do you have anything to sum up?
No, I've got nothing to sum up. I think possibly the only thing that I would say is that the outdoor area that is looking to be licensed can only be accessed from the actual property, from the hotel itself. You can't access it from the car park. So the staff should be able to monitor, and once that area is closed, patrons shouldn't be able to go and sit in that area, where some outdoor areas still have the opportunity for maybe somebody to go and sit, but because you can only access this area through the side, then it would be up to the management to be able to control that.
That's fine. Thank you very much for that. And Mr. McIver, do you have anything you'd like to say in closing?
No, the only thing I would say is I would confirm exactly what Ms. Godini has said there. It's a self-contained unit, if I can put it that way, as far as you can't access from the streets, so to speak. Yeah.
Okay, thank you very much. Can I move on then and ask if the board members require legal advice from the clerk?
No.
No, I'm seeing no indications. So if I could ask the Deputy Clerk to outline the terms of the legal test for the application, please.
Certainly, thank you. The legal test is set out in section 30 of the Act. The board must consider whether any of the grounds for refusal apply, and if none of them apply, then the board must grant the application, or if any of them apply, they must refuse. The grounds for refusal are set out in Appendix 5, page 181 of the agenda pack. If considering a grant of the application, please note you may make a variation to the conditions to which the licence is subject to, should you wish.
Thank you, Suzanne. So do board members wish to retire to deliberate for this one? No. Okay. So I will now, in that case, open the matter to debate for the members, please. Anybody wishing to start us off? Ms. Sullivan, Mel.
I was going to say I have no problem with this one. I'm happy for it to go through.
Thank you very much. Short and succinct, I like it. Mr. Goodall, Jeff.
Thank you. I might not be quite so succinct. I like the sound of my own voice too much. Sorry about that. I also don't have a problem with this one. Thinking of the location of the hotel, which I know reasonably well, and the position of where this unit is, there's not a lot of houses about there. Facing across the road, it's retail units. To the right's the car park, to the left is the roundabout. So, and I'm quite happy with the answers that Mr. McIver gave as to, and also the manager, as to when the area would be clear. So if there's nothing after 10:30, I have absolutely no problems with it. Thank you.
Thank you. And Ms. Nichol, Jenny.
Thanks, Chair. Yeah, no, I'm of a similar thought, and yeah, I've given the objection credence. I think though, if we were minded to grant, I'm not preempting it, I think it would be important to make sure the objectors are aware of what they can do if there are any concerns and how they can complain about those in the future. Because I think maybe that's a little bit missing for me. I think if there is anything going forward for them, what would give them peace of mind, and I think that might help in the future. Thank you.
Okay, thank you very much. Okay then, oh no, Jenny.
No, it's just stuck.
So can I confirm then, moving on, do you feel that you have sufficient evidence from which to make a decision?
Yes.
Yes.
Yeah. Okay. So in that case, can I call for a motion from someone, please? Mr. Goodall, Jeff.
Trying to hold it back a wee bit so someone else could do it. Yeah. My motion would be to allow this application to go forward. I think all of our objectives are met, and I'm sure that if there was something that Lisa would have picked up on it, and I'm quite content with the investigations and the application as it is.
Okay, thank you very much. And Jenny Nicol, let's go ahead.
Yeah, I'm happy to second that.
Happy to second.
And to make sure that the objector does get the information there for how they deal with issues in the future.
Okay, and so we are looking with that motion to grant subject to the local conditions that are held within the report as well. Yes, just a confirmation.
Yep.
Yep. Okay.
So you're waiting for me. I apologise.
You put the motion forwards.
Thank you.
Okay, so can I ask, and I don't see any other indications, can I ask if there is any amendment coming forward? No, I don't see anybody. So if there's no amendment coming forward, can I just clarify and ask that that is a unanimous decision by the board?
Agreed.
Agreed.
It is.
Yes.
Yes.
Okay. So in that case, can I ask the Deputy Clerk to confirm the board's decision, please?
Certainly. So the members of the board have found that no grounds for refusal apply. Therefore, the application is granted as recommended in the report, and this has been by unanimous.
Okay, thank you very much.
Thank you very much, Your Honours.
Thank you very much, Mr. McIver, for attending for both of those hearings.
I'm away for a lie down now.
We'll keep going. Okay, thanks everyone. Okay, so we're moving on then swiftly to number 8 on our agendas, which is the application for a major variation of a premises licence hearing for Balmoral Estate in Ballater. So can I confirm that the relevant parties are in the meeting, please? Because it has been a while.
Yes, I'm here, Chair Neil Fraser, acting for the applicant.
Wonderful, good. And I think our LSO for this item is Keith Simpson. Simpson, you're present?
Yes, I'm
Yes.
here, Chair. Yep.
You're here, perfect. Thank you very much. Okay, so if I can ask the Deputy Clerk to outline this application, please.
Yes, so you're presented here with a report relative to a major variation to the premises licence, which variation includes the increase in capacity to an outdoor drinking area, a change of layout plan, and that increase in capacity for sales, on sales, both internal and external. As I say, there's been an increase in capacity for the outdoor area. It's quite a significant increase by an additional 104 covers. Internally, the internal additional capacity is only an additional 27. This application requires to be determined by the board as the applicants have not agreed to the local conditions 34 and 35, and the board required to consider a departure from policy as requested by the applicant. We've received a representation from the LSO Keith Simpson in relation to the application, and this can be found at Appendix 2, starting at page 258. Local to Condition 34, you will see Appendix 3, page 266 of the report, is that no amplified music is to be played in the outdoor area. The outdoor drinking area is to be delineated by a barrier, and subsequently signage displayed advising that alcohol cannot be removed from that area. Condition 5, as you can see at page 267, is being that children and young persons can be permitted in the outdoor area for the purpose of consuming food. The procedure we will follow is you will hear from the agent for the applicant who will speak to the application. Then you'll hear from the LSO in terms of his representations. The applicant's agent will then have the opportunity to address you in respect of any issues raised by the LSO. Then members may then ask questions. The convener will then ask the LSO, the agent for the applicant, for concluding remarks before we consider the application. Members may deliberate and ask for legal advice. Thereafter, confirm you have had sufficient information before we call for a motion and any amendment, and vote if necessary before confirming the decision of the board.
Thank you very much. So I will move swiftly on to Mr. Fraser, if you would like to speak to your application, please, and what the reasons that you are objecting to the local conditions as specified.
Thank you, Chair. Good afternoon, Your Honours. I have lodged written submissions in relation to this matter, and I'll speak to them, but I don't intend to just rehearse everything that's written down. I hope that's available to you. There are some images alongside those written submissions as well, which may assist if you have those in mind while I'm describing these areas. Hopefully they'll illustrate what we're talking about. As the Deputy Clerk has indicated, the application was for a general increase in capacity, both on sales and off sales. I don't intend to dwell on that, as it's not the controversial part of this application. I am, of course, happy to answer any questions you may have about those particular aspects of it. So, concentrating on the contentious issues, those are whether local conditions 34 and 35 should be attached to the premises licence. They're not attached at the present time. The last time the licence was up for a variation, it was under the previous plan, so those conditions hadn't been drafted yet. There were some conditions previously attached as special conditions, which touch on, I think, the conditions which appear in 34. My understanding of the report that's before the board today, and particularly paragraph 3.10, is that it's intended to remove all but one of those special conditions and essentially replace them with 34 and 35 as local conditions to avoid doubling up. I've no difficulty with the removal of those special conditions. The question is whether they should be replaced with 34 and 35. So if I can turn to those, they're in two categories, I would suggest. The first is a kind of good neighbour category, being a prohibition on amplified music, a requirement for the whole of the outdoor area to be delineated by a physical barrier, and a display of signage indicating alcohol's not to be removed from that outdoor area. And I would categorise those as the good neighbour provisions on the basis that if you're in an urban setting, if you're one amongst several licensed premises, and in the neighbourhood of residential premises as well, you don't want loud music playing. And you also want to know who your customers are, and your neighbouring premises want to know who their customers are. And importantly, if the police need to be involved in any capacity, they need to know which outdoor area relates to which premises. These are all perfectly understandable and reasonable conditions. The thrust of my submission is they don't really have any practical benefit for this particular premises, which is entirely self-contained within a private estate. There are no neighbours, residential or otherwise, that would be impacted by the kind of activity that these conditions are directed to. So that's the thrust of my submission. The second, that was the first category, the kind of good neighbour ones. The second one is about children and young persons. Has a bit of a difficulty with this condition because it isn't really a condition as drafted in the local conditions, and I've kind of outlined that in my submissions. It's a permission. It says that children and young people may be allowed in this area for the purpose of consuming food. It doesn't say they're not allowed in that area for any other purpose. Okay, so as drafted, I don't think it does what the board intended it to do. But even taking the board's, what I presume to be their intended interpretation, I don't think that's necessary for these particular premises. For one thing, again, if we're going to compare these premises with other, perhaps urban premises with beer gardens, that kind of thing, again, it's not an unreasonable condition to apply automatically as a local condition that children aren't going to be, or children or young people aren't going to be in a beer garden unless they're in there for a meal with their families. That's not really analogous to these particular premises, where members of the public who are there with their families are there as tourist visitors. They're there as a destination. They're there to visit. They're there perhaps to have a meal and a glass of wine and a beer with that meal as part of the visit, and then they're then going to leave. They're not going on to any other licensed premises, and you're not going to have a transition in character with these licensed premises. The board will be aware that what's appropriate for a child or a young person to attend at 2 o'clock on a Sunday afternoon is not necessarily appropriate at 10 o'clock on a Friday night, even though the premises may be identical. The atmosphere and the character of the premises may change over those times. That's not how these premises are operated. That's not the effect that would be had. The particular layout here is that there's an inside area and then there's an outside area. And the two areas are very, very closely linked. There's large, big, double French windows that open up and essentially make them the same area, certainly in good weather. And there is no such restriction on the indoor area. So there's no restriction on the indoor area saying that children can only enter that area if they're there for the purposes of consuming a meal. So my submission, it's illogical to apply that restriction to the outdoor area in respect to this premises. If there's no reason for it internally, there's no reason for it externally, given the specific nature of these premises. I understood that you were referred to the LSO's comments on this. My understanding, and I hope the LSO will confirm this, is that after discussion about the particular character of this premises, the LSO is not of the view either that condition 34 or 35 require to be applied to these premises, as I say, specifically because of their the character that they have. I don't intend to say anything further in support of the application at this point. As I say, my written submissions are there. There are images. There are also YouTube clips showing an animated flyover of the developed premises. If any further characterisation of the specific area is required. Other than that, I would invite your honours to grant the application with the variation to remove the existing special conditions mentioned or omitted from the report. Perfectly happy to leave in the special or specific condition that children and young people are only allowed to entry accompanied by an adult 18 years or over, and that they're not permitted entry to the bar areas. There's no issue with that specific condition remaining attached. Other than that, I would invite you to grant the application. Happy to answer any questions that you may have.
Thank you very much, Mr. Fraser. And I must admit that those links to the YouTube videos were very, very helpful in enabling us to visualise exactly how the layout is there. I'll move on and ask Keith Simpson, LSO, to speak to his representation, please.
Yes, thank you, convener, board members. Good afternoon. Yes, this hearing relates to a variation application to the premises licence for Balmoral Estate. The variation seeks to change the layouts of the buildings with an increase of capacity of the premises for both on and off sales. The variation also seeks to add an external seating area adjacent to the building. Mr. Fraser has clearly set out his reasonings behind his objection to the certain conditions, but the area of contention with this application appears to be whether conditions 34 and 35 of the pool of local premises licence conditions contained within the Licensing Board statement of policy should be attached to the premises licence. In relation to outdoor licensed areas, the policy seeks to attach conditions 31 to 35 to all such areas, and the applicant is seeking a departure from policy in relation to conditions 34 and 35. Again, Mr. Fraser has gone over what conditions 34 and 35 relate to, so I don't propose to do that again. But what I can say is that consultation, I've spoken to the applicant's agent, and there is a general consensus that due to the nature, the character, the rural location, and the demographic of the type of patrons, that conditions 34 and 35 would be unnecessary in this situation. I'm therefore of the view that I would support a departure from policy in relation to conditions 34 and 35 in this case. It's for your consideration, and thank you. I've got nothing further to add.
Okay, thank you, Mr. Simpson. Can I ask Mr. Fraser, do you have any response to the submission by the LSO?
No, nothing further rises. I had understood that was his position. Thank you, Chair.
Super, thanks very much. So now I'll move on and ask if any board members have questions of the parties. If I could indulge and go first. If I could just ask, you mentioned that you had special conditions attached to your previous licence before you've put in for your variation. Can I just seek clarification what those special conditions were?
Thank you, Chair. They're very similar wording to, but still a bit different from the conditions that appear in 34. So it's the signage, the barrier, and the amplified music, if I can summarise it that way.
Right, okay. Harriet, could I bring you in to clarify exactly what was in and how the new local conditions since the policy change differ from what is already existent?
Thank you, Chair. I would just like to clarify, so before the new policy was published, we would obviously put specific conditions on to relate to an outdoor area. The new policy was then published with specific condition, local conditions in specific areas to delineate outdoor areas. Mr. Fraser was correct in saying that, the specific conditions would ultimately be replaced by our local condition wording because it would be down as a local condition and not a specific condition. It wasn't actually indicated as part of the application process that those conditions were to be removed with this variation, but what we'd elected to do was to replace them with the local conditions. However, the applicant hasn't agreed with those conditions. So I believe Mr. Fraser is also asking the board to consider if they aren't to be granted here, they are to be removed from the licence. However, that wasn't specifically stated in the application form. But if the board is happy that they're satisfied that the conditions don't relate, aren't specific in the circumstances, if they're happy, I'm sure Suzanne can keep me correct, that those conditions can be replaced and local condition 34 and 35 might not necessarily be applied.
Right, okay. Thank you very much for
that.
To
come in the back of that, there are two specific conditions in relation to children and young persons which will remain on the licence, that they aren't under question just now. So if the Deputy Clerk could just confirm the legal standing in relation to the specific conditions, Mr. Fraser might be able to correct me. I believe there must have been an outdoor area previously, but I think we're expanding upon it, and that purpose has now changed, and the local conditions or the specific conditions that were previously applied no longer fit. But like I said, that wasn't brought up as part of the application form application process, so it wasn't advertised like that.
Okay, Mr. Fraser, is that your understanding?
That's my understanding, yes.
Yeah. Okay, thank you. Okay, I'll move on and I'll bring members in. Mr. Goodall. Oh, you've taken your hand down. Was that in preempting me up calling you?
No, so my question's been answered. I was interested in the legalities of what we were doing, and that question has now been answered. Thank you.
Perfect. Great. Thanks very much. Mr. Taylor, Ian.
Yes, thanks, convener, and thanks, Mr. Fraser, for your presentation. And I wish to just develop a little bit more the idea of the good neighbour, which I think you're to be congratulated on. I appreciate that this circumstances is different from what the good neighbour that you were describing in a bit more built-up environment. But I did note that some of the plans, there was reference to Colt Cottage, Palmenier Cottages and Royal Mews, which I guess must be private residences, or at least residents of families. And I just, and you commented too about, and I suspect the whole development will be geared to tourists and visitors and such like. But one aspect that they may well undertake is to go and explore. And I do wonder if in the exploring that they're likely to do and wondering about the site, whether you do wish to have some degree of control as to what is available to the public to wander in, or what might be described as out of bounds. I wonder if you'd care to comment.
Thank you, Councillor. I'd be happy to do so. On the last point, in terms of control over the premises, as you might imagine, there's quite a layer of security at the premises anyway, and members of the public are not free to wander over the whole site. It is a controlled location, perhaps more so than most of any premises license that this board would manage in terms of special branch and so on, just given the nature of the premises. So in terms of members of the public wandering off somewhere, that's not going to happen. In terms of having some control or some indication, I think I indicated my written submissions, but I didn't touch on it in my oral submissions. I think it's condition 34B is in relation to signage saying you can't take drinks out of this area. The applicant has no particular difficulty with that condition being in place. I'm conscious that the LSO is the view that wasn't particularly necessary either. I have to say the applicant's view is that it's not particularly necessary either, but the applicant wouldn't wouldn't put up any serious resistance to having some sensible signage around the building saying, look, any alcoholic drinks sold have got to be kept within this location, if that would address your concerns, Councillor.
Thank you very much.
And if I can bring you back to Mr. Taylor's first question, which was about the houses that are nearby.
I'm afraid I can't speak to the occupants of those houses, but my understanding is that not that they're privately let to members of the public. This whole estate is operated as one entity, in effect. Okay. There are at certain times of the year there are many residents on the estate who come from outside the estate to support the court when the royal family are in residence there, and there's a lot of accommodation provided there for all kinds of support for that function. That's not to say that is used all year round, and it's not to say that during those times the public have any access to the estate at all.
Yeah, so it's not that those are
specifically.
It's not that those are private residences that have got permanent residents in them. It's more that it is people that are working either for the royal family or for the estate that are resident at occasionally.
So I'll just make sure I'm as clear as I can be here with reference to the plans. So I think we have layout plan C shows the whole site. This is the new proposed layout plan C, and it's the widest angle that we have, and we've indicated on there the hatched area that's all the sole private estate belonging to this applicant. So every building under that hatched area is part of the one estate. When one zooms in on Plan D, which is the closer plan to show the particular buildings in more detail, there are a number of buildings that are picked out there. Your Honour's quite correct, picked out there as particular cottages. I'm afraid this afternoon I can't tell you what the particular occupancy or leaseholding is for any one of those individual properties, but they are all owned and managed by the estate.
Okay. Does that help, Mr. Taylor?
Yes, thank you very much.
Thank you. I don't see any further questions, so I will invite our speakers to come back in with any closing remarks. That you can't add any new evidence at this stage. So in reverse order, Mr. Simpson, do you have anything to say in conclusion?
No, thanks, Chair. No, I've got nothing further to add.
Okay, so over to you, Mr. Fraser. Do you have anything else you'd like to say?
No, just to sum up, because we've been backwards and forwards a little bit in these conditions, moving the application as a whole, you're quite right that there was an existing outdoor area. It's just increasing in size. We can put in more tables for the sunny weather, obviously. There are currently existing specific conditions. The report and the clerk's quite correct that we didn't seek at the outset of this to remove those. As the application has developed, and particularly when we've seen the detail of the local conditions, we realised actually the current character of the premises, they're no longer necessary. So my invitation to the board is that the application be granted, the existing specific conditions be varied such that the ones relating to signage, barriers and amplified music be removed. The other two conditions relating to children and young people remain attached to the licence, but that conditions 34 and 35 of the local conditions are not attached to the licence. That would hopefully clarify my application this afternoon. And I think the board does have power to do that in terms of the general power to vary whatever they would like on the occasion of granting a variation under section 30 subsection 6 of the legislation. Thank you.
Thank you, Mr. Fraser. Can I ask then if board members require any legal advice from the clerk before we move on? Okay, I am seeing no indication. So if I could ask the Deputy Clerk to outline the terms of the legal test for the application, please.
Yes, thank you, Convener. The legal test is set out in section 30 of the Act. The board must consider whether any of the grounds for refusal applies, and then if none of them apply, then the board must grant the application, or if any of them apply, the board must refuse. So the grounds, as I say, are set out in Appendix 5 to the report. And if consideration is given to grant the application, then you may also make a variation to the conditions to which the licence is subject to.
Okay, thank you. Do the board members feel that they need to retire to deliberate before we move on? No, I'm seeing shaking heads. So in that case, then I will open the matter for debate. Who would like to kick us off? Mr. Taylor, Ian.
Thank you. Because this is an expansion of an existing facility, let's call it, and therefore it's operated already. I don't have any major objections to supporting the application and allowing it. As I've discussed and Mr. Fraser has commented, I think maybe discrete signage may be useful, and I would be happy if that was to be added as a condition.
Okay. Thank you, Mr. Taylor. Anybody else like to come in? Harriet.
Mr. Taylor, could you just confirm, I just want to confirm that there is already a condition on the licence saying that signage is displayed indicating that no alcohol is to be removed beyond the licensed area. Is that what you were already confirming?
It was exactly that I was confirming.
Yes, so we wouldn't need an additional condition to be added because that's already on the licence. I think, Mr. Fraser is stating that there's already 6 specific conditions in relation to that. I don't know if the board could ask Mr. Fraser to confirm if his clients are also no longer require the 3 that's already been granted as part of his submission today. Like I said, that wasn't previously stated on the application though, but the signage, we've got a condition that's saying the area is delineated by a physical barrier or similar, which is already on the licence. Signage is displayed indicating that no alcohol is to be removed beyond the licensed area and that no amplified music is to be played therein. That's what's already on the licence.
If that's the case, I'm happy. Thank you.
Okay. Mr. Goodall, Jeff.
Thank you, Chair. Just to say that I have absolutely no problems with this. I don't know if anyone else has. Keith Simpson seems to be quite content, so I don't see any point in seeing anything else, really. Seems to be fine.
Okay, thank you very much. Does anybody else wish to come in on this one before we move on? No, I'm not seeing any indications. So in that case, I will ask members if you feel that you've got sufficient evidence upon which to make a decision.
Yes.
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 Okay, good. In that case, can I call for a motion, please? I'll go. No one else is putting their hands up. I said it first. I'm in agreement with Mr. Goodall and Mr. Taylor. I mean, I do think that the common sense decision is to allow this variation without local conditions 34 and 35. The fact that Mr. Simpson, our local LSO, is content with that in this particular instance. Given the nature of the premises, I think that's absolutely fair enough, and I'd be content to put forward a motion that is what we do. I'd seek a seconder. Mr. Goodall?
I will second that motion. Thank you.
Okay, thank you. Suzanne, you need to come in?
Can I just ask you to clarify what you would like to do with regards to that request from Mr. Fraser in respect of that removal of the specific conditions that are in place, the 3 that he referred to?
Yeah, as has already been discussed, the local conditions kind of replace the specific conditions and they cover the same ground. So the fact that we're willing to forego conditions 34 and 35 would mean that we're content to remove the specific conditions that are currently on the licence. Am I correct in that summation? I'm not seeing any dissent, so so I think so, yes. Okay, is there any amendment being put forward? No, so everyone's content with that decision? Unanimous?
Yes.
Yes. Agreed.
Yeah, agreed. Okay, thank you very much. So can the Deputy Clerk confirm the decision, please?
Yes, so we have a motion sitting with yourself, Ms. Black, with the recommendation to grant the application with departure from policy in respect of conditions 34 and 35, and also removal of the specific conditions relating to the signage, the barriers and amplified music that are currently on the licence. And that is seconded, I understand. I think I just missed it. Was it Jeff Goodhall that seconded it? I was busy writing.
That's correct. Yes, he did.
Thank you.
He did. That's great. Thanks very much. So is that all clear, Mr. Fraser?
Yes, absolutely. Thank you very much, Chair and Your Honours.
You're very welcome. Thank you for your attendance. So I can confirm that this hearing is now concluded, and thank you for your interest in this business. And we will move on to the granting of occasional licences, repeated occasional licences, and occasional extensions. So if I could ask the Deputy Clerk to, we've only got one today, I believe, if you could outline the terms of this application, please.
I was just wondering whether you wished me to confirm the decision before he left, as he's left the meeting.
Right, sorry, I thought we had done that.
Yeah, we had, but just before he leaves, we generally would come back to that. Sorry.
Yeah. I think, you know, it's
everyone's
clear what we've just said 2 seconds late before.
Yeah.
So yeah, sorry,
the decision was confirmed, but I'll just confirm it was to recommend the grant of the application with departure from policy in respect of conditions 34 and 35, and removal of those specific conditions relating to the barriers, the noise, and the signage, which are currently on the licence, and that was unanimously decided. Thank you.
Yeah, thank you very much for keeping me right. Okay, so now we're moving on to the occasionals, the repeated occasionals. So just before I get the Deputy Clerk to come in, I will actually confirm that Mr. Tong, Alistair Tong, is still here.
Still here, present.
In the meeting. Still here. Thank you so much for your patience. And confirm that Lisa Godini, the LSO, is present as well.
Yes, I'm present. Thank you.
Perfect. Thank you very much. Okay, so Deputy Clerk, if you could outline the application, please.
Certainly. So thank you, Convener. These applications are before the board today because the applicant has been operating under a repeated occasional licences, and the board's policy is that the clerk has delegated powers to grant occasional licences for unlicensed premises, whereas for no detailed specific event for up to a period of 3 months. Beyond that, applications are not granted by the clerk and are deferred to the board for determination. The applicant is expected to explain to the board why an application for a premises licence has not yet been made. There is a history of applications dating back to 13th July 2024 demonstrating a pattern of occasional licence use for regular trading, and this can be seen before you in the report. You now have before you 4 applications to be determined for trading from 13th November through to 6th January 2025. Harriet will be able to provide an update on the position of any premises licence application, but there is an official representation from our Licence and Standards Officer, Lisa Godini, in relation to the latest applications which are highlighted in the report. Ms Godini's report can be seen at Appendix 2, page 331 of the agenda pack. It's for the board to determine whether these applications are to be granted today based on the explanation that may be given by the applicant. The procedure will be to hear from the applicant, thereafter to hear from the Licence and Standards Officer, to hear again from the applicant with a response, and then any questions that the members may have, followed by concluding remarks in reverse order, and then for the board to reach a determination. When reaching that determination, the board also required to be mindful of determining how you wish future applications to be dealt with. Prior to handing back to the convener, I'd like to take this opportunity to ask Harriet to confirm whether or not any premises licence application has been received to date.
Thanks, Suzanne. Currently, there is no premises licence application in the system.
Thank you very much. Okay, so if I could move things along and ask Mr. Tong to outline the terms of your application to the board, and that you may wish to address the concerns raised in the representation at this time, although you will get a further opportunity to address the board after other parties have spoken. Please go ahead, Mr. Tong.
Thank you very much. Good afternoon. I know it's been a long day already, but very interesting. I am the owner of, along with my wife, of the Spider and a Bicycle premise at Unit 3 Station Square in Aboyne. I do recognise 1 or 2 faces as maybe have been coming in and seeing us, but just for description, the Spider and a Bicycle Cafe is a small, very small unit. It sits within what was once upon a time the waiting room of the train station at Aboyne, and consists of, as sketched out on page 10 of 10 of your Appendix 1, a document which is possibly a good thing to be having a quick look at this now, save me a lot of verbal description. It's a one-room operation. It's served with a small servery counter, leads into a very small kitchen area, and the toilet area and the front door and lobby. Those last three items would once upon a time have been the passageway that the luggage porters would have taken in the luggage down to, and is now an enclosed area. So the reason I emphasize that is that the most significant challenge in Spider and a Bicycle, it's a very good little coffee shop, but is storage and space. When you sit in the cafe, in the restaurant area, then everything that you can see is all there is. There is no back storage area. There's no extra space. There's no area outside that could be added onto or whatever. So refrigeration and cooking space and dishwashing space limits everything that we absolutely do along there. There is one attic storage space which can be accessed through the kitchen by Ramsey ladder, and previous occupants used to put all the crates of soft juices, etc., so the outers up into that space, and then we'd take down bottle by bottle as required. That's obviously not very good. And to the front door and lobby area, first thing I did was put in storage space so that those soft drinks can be in that area there. How is that relevant to what we're speaking about today? Well, we're maximising what we try to do in the cafe. As I say, it's basically a coffee shop and cakes and bakes. We now do some light lunches. We now do evening meals where possible. We've developed and doing quiz and curry nights, which started off from a licensing point of view as a bring your own bottle. And then actually LSO Mr. Simpson kindly came in and introduced himself one day in the passing and said, "Why don't you have a license?" And I said, well, the main reason I don't have a license is because I don't have the space to have any stock, basically. And if I sold a bottle of wine, I would need space in the cafe to store at least 4 bottles of 4 wine glasses even. So that in itself is a whole challenge, and was the reason why it's not something that I thought I could do. However, I was encouraged and informed that yes, I could for a while experiment and see how we got on by having a series of occasional licenses, and hence I started doing that in July. Since then, I have bought an additional display fridge, standalone fridge, which sits near the fire exit door, and that now has a small stock of a couple of cases of wine in it and a case of beer, and indeed some glasses in the fridge there along the ways. I've amended the storage space. I've added some storage space by taking away some seats and putting in box bench seats, so that my customers are now actually sitting on my wine storage area in the top right hand corner of that sketch. I had the pleasure of sitting with the LSO yesterday and giving her a visual of where everything is and how we've maximised what we can do, and I can't see how we can do any further. But so having operated on occasional license for a while, I'm fully aware that we need to get to a point that I either apply for a premise license or that I stand down and go back to bring your own bottle or less. I've now decided, along with my wife, that we would like to work towards getting a premise license. The economies of it, I'm still not quite sure, but it will allow us to do things of the evening where, as I say, my curry and quiz nights, etc., are quite successful, and therefore it opens the door. Why not pull the trigger on it yet is I've just made that decision, to be honest with you, having traded under occasionals for the last couple of months. I've been distracted from fully benefiting that with my father, unfortunately, became ill and passed away last month, so that took me away from really focusing on how much I can achieve with a full license. However, as I say, I've now made the decision to do that. Will I do that immediately? As spoken about with Lisa yesterday, the one variable in the future, possibly, is I'm already in discussions as of as of June this year. I was in discussions with another department within the council, considering whether to be able to utilise the areas to the front of the building as an outdoor seating area where I might be able to serve a few cups of coffee at 2 or 3 tables in what is currently 2 disabled parking spaces. And the idea was to move the disabled parking spaces elsewhere and allow me to put up a small area out the front there. So with the timelines that were required with that was pushed back to being my winter project to speak with the council and see if that can get done and ready for summer next year, because that would have to go through at least an 8-week planning permission process, which would have taken me right past summer this year. So that was going to be my winter project. In discussions with Lisa yesterday, of course, if I did that, that would change and require a major variation to a full premise license that I would have. So therefore, I am probably seeking or hoping that you would all consider allowing me to continue as I am until such time as I can sort out whether or not that major variation could be applied. The other factor, and not complication, but not even a challenge, but the other factor is that I am an existing personal license holder. I'm the premises manager for our other business at Kincardine O'Neill Village Store, which we've operated successfully for 6 years. And my wife would have to undergo the training to become the premise manager with a personal license there. And I would become the personal license holder and premise manager for the full premise license at Spider and a Bicycle. So more than that, I'm not going to say. Hopefully Lisa will endorse what I've said or give further detail or guidance to yourselves. Thank you.
Okay, thank you very much, Mr. Tong, for a thorough explanation of your position. Can I now ask Ms. Godini to the LSO to speak to her representation, please?
Yes, thank you. The LSO representation is in relation to 4 occasional licence applications, the first to run from the 13th of November 2024 and the 4th until the 6th of January 2025. These applications have been brought to your attention as the applicant has been applying for occasional licences to take effect from mid-July 2024. So to date, there has been 9 occasional licences granted, with 4 presented to you now for consideration. As previously mentioned, 4.45 of the Aberdeenshire Licensing Board policy statement relates to the repeat use of occasional licences, where it is detailed that businesses using occasional licences for a period of over 3 months will not be granted by the Licensing Board under delegated authority, and the applications must be considered by the Licensing Board themselves. As been mentioned by the applicant, Mr. Tong, I have recently provided the applicant guidance on applying for premises licence and met with him just yesterday morning to discuss further. During this time, we discussed the challenges that had been faced over the last couple of months and how the business is still in its infancy under his new ownership. I understand that the occasional licence applications have been used as a way of identifying if there's a demand for the sale of alcohol and therefore a requirement for a premises licence long term. Whilst it does appear that alcohol sales have been and will be remain secondary for the business, the applicant has identified that a premises licence would be an advantage for evening trading, specifically organised theme events, and has committed to myself, as he has done with yourselves, that this is something that he would like to progress. Should the Licensing Board be minded to grant these applications, then in my representation I have recommended conditions to apply to the granted licences. These are from the pool of local conditions set out by the Licensing Board in addition to Schedule 4, which is attached to all granted occasional licences. These conditions have been recommended for all previous occasional licence applications and have been agreed previously with the applicant. Thank you.
Thank you very much. Mr. Tong, can I ask if there's anything you wish to add, having heard the Licensing Standard Officer's submission?
No, I don't think so. No challenge there whatsoever. Delighted to be working. In fact, I'd just like to, what I would like to add is, yes, both Ms. Gadini and Mr. Simpson have both worked with me in the past and been very helpful, and I have been appreciative of that and look forward to continuing to do so.
That's good to hear. Thank you for that.
Thank you.
I would invite board members now if you'd like to ask any questions of the applicant or the LSO, please. Anybody? Mr. Mason, Trevor. Oh, you're muted, Trevor.
Sorry about that. Yes,
okay.
Mr. Tong, you mentioned how small the place is. There is customer toilets there. Are the ladies and gents there, or I just want to confirm that, that's all.
No, there is one toilet that is therefore unisex and disabled, provided as per building warrant requirements.
All right. Okay, right. Thanks.
Thanks very much. I'm not actually sure that's within the remit of the licensing board, but thanks for the question.
I'm not sure whether I would love to give a license out without toilets.
Well, there is a toilet. There's provision which,
yes,
as was said, is sufficient for building warrant regulation for that size of premises and covers, I think. Harriet, would you like to come in on that?
I would just like to take this opportunity to just let members know that when a premises licence comes, it does go out for consultation to departments such as building standards and environmental health that would provide comment on these issues if they were, to need further clarification.
Thanks very much. Anybody else any questions for the applicant at LSO? No. Oh. Mr. Tong, you'll get the opportunity to speak in a moment. No just problem. Asking the members if they have any further question just now. No. Okay, I'm not seeing anybody else. Okay, so I will just now ask for closing comments. So if I can go to you, Ms. Gadini, first. Do you have anything further to say in closing?
No, I've got nothing further to say. Thank you.
Thank you very much. And Mr. Tong, do you wish to say anything in closing, being reminded that you can't add any new evidence at this stage?
All right, I won't tell anybody that the amount of covers we have is for 32 people.
32. I think you did mention that during your submission.
Yeah, it's not a great deal of requirement for the toilets, etc.
Yeah, that's fine.
No, I have no further information. Hopefully, you'll be grant the request basically and help me to get this out of its infancy.
Thank you very much. Do board members require any legal advice from the clerk for this item? No. And so if I could move on and ask the Deputy Clerk to please outline the terms of the legal test for the application, please.
Certainly. So the legal test is set out in the board's supplementary policy statement 4, as can be seen at Appendix 4, starting at page 334 of the agenda pack. There would appear to be no grounds upon which you can refuse these particular applications today. The point was to try and ensure that the applicant moves towards submitting and obtaining a premises licence going forward. It's recommended that any grant is made subject to the standard local conditions and specific conditions as requested by the LSO and police, as stated within the report. However, I'd also ask the board to consider how you wish for future occasional licence applications to be determined and whether you wish officers to continue to proceed to process further applications under delegated powers, or whether you wish future applications to be deferred back to the board. A third alternative would be that officers can consider future applications following consultation with the convener and vice.
Okay, thank you very much. Do board members wish to retire to deliberate on this one? No. Thank you. So I'll now open the matter to debate then, please. Mr. Goodall, Jeff.
In this one, I don't think we have much to debate. Everything seems to be fine. We can't refuse, and Mr. Tong is proceeding correctly towards full licence and applications. So I don't see any issues at all with this one.
Okay, thank you very much. Mr. Maynard, Richard.
Hi. Yeah, I agree with Mr. Goodall there. I think the gentleman's moving in the right direction. Bit concerned about the timeline, maybe, but I understand the difficulties and problems he's having. So, yeah, no, I think we should move forward with this one and just grant. But I'll be happy to propose that at a later date if somebody else doesn't want to do it. Thank you.
Okay, thank you. Mr. Mason, Trevor. You're muted still.
My hand didn't come up there. It's sorry. Yeah, the yes, I'm quite happy with this application. I think we should go ahead. The point I was bringing about the toilets is there is a cafe in Ellen that doesn't have any toilets in. That people are told to go across the road. It's just to let you know about that. They don't have a license, so. Yeah, okay, thanks.
Interesting. Okay, that's for another forum, I think. Mr. Taylor, Ian.
Yes, thank you. I'd just like to congratulate Mr. Tong, really, in terms of his use of occasionals as a toe in the water, seeing how things are going. To my mind, that's exactly what they should be. And I'd also like to congratulate him on his very informed and considered responses, both in terms of how he would wish the young business to develop and see how it goes in the future. Wish him every success. Thank you.
Thank you, Mr. Taylor. Mr. Crowson, Jeff.
Yeah, I think Councillor Taylor's just covered my points. I think we've been here before. I don't see any reason to issue licences. Apart from, I don't think we should let Mr. Tong go without asking him where he came up with that excellent name from.
Yeah, that would be really interesting to know where the name came from. Yes.
Would you like me to answer?
Yes, please, if you would. I think it's a cracker.
I need the chair's permission. I was told that strictly yesterday.
Yes, please go ahead, briefly.
All right, very, very briefly, because there's not a day goes past that I don't get asked this question. The name Spider on a Bicycle, as I've already stated, our premise was the waiting room at a Boyne train station. It's a beautiful room. And when the two ladies that put it together, who I think maybe I even did apply for a provisional license once upon a long time ago, Holly and the two girls that put it together anyway, my mind goes, put together the cafe and said, what are we going to call this? We don't want to call it anything foodie because that will restrict us and we'll always have to be the baked tatty or the softie or the bacon roll or whatever it is that they picked on. And they didn't want it to be the station cafe because there's a station cafe everywhere you go, wherever there was ever a railway. So one day, Holly and Emmett said, oh, do you remember the book that Mum used to read the poetry out of us? What was it called? It was called, it was Spider on a Bicycle, wasn't it? And they were nearly right. The book is actually called The Spider Bought a Bicycle. So when you ever come and visit to see whether we really do have toilets or not, you can have a read of several copies of the book which I've procured from Amazon and are now available in the restaurant. And it does exactly what it says in it. It gets people talking about the local cafe that they went to in Aboyne. And it's memorable and it serves its purpose to this day. So that's where it came from. It was a childhood poetry book that inspired the name.
Thank you. It saved me a lot of Googling after this meeting.
that is fascinating, and yeah, it's always good to have a unique name, that's for sure. Okay, so moving forward then, we need to go to a determination. Can you confirm, please, that we've received sufficient evidence on which to make a decision?
Yes.
Yeah. Good.
Yes.
Okay. So moving forward, I would actually like, if that's okay with everyone, to call for a motion and put a motion forward. I'm in concurrence with my colleagues in that I think we should grant these occasionals. I think it's a wonderful wee business, and I commend everything that you've done so far, and your plans moving forward sound fascinating, and I wish you all the very best of luck. However, we do have a policy that you can't trade on repeated occasionals. So it's really good to hear what your plans are moving forward. But I would like to also put a time limit on the amount that we will allow this to happen moving into the future, to ensure that you move forward with that full licence application. So considering what you've already said about the potential of using an outdoor space and needing planning permission for those kinds of things, we need to give a certain amount of time for that to happen, so that you can put a full and complete application in, so you don't have to vary it in the future. So I would make a suggestion that we pass these occasional licences, and then future occasionals that come in would be delegated to officers for a period of 6 to 8 months. So taking us to either the 30th of April board or the June the 25th board. So thinking about how long planning it takes, I'm thinking perhaps the June board would be more realistic, and would seek a seconder. And yes, subject to the conditions that are within the report, the local conditions, etc. Mr. Crowson, Jeff, sorry.
Could I just come in before
Suzanne, you wanted to come in?
Yeah, sorry. Just to be, I guess the timing of when that comes back to the board is important, and making sure the dates align in relation to any occasionals that may have been granted, delegated prior to that. So I'll maybe just get Harriet to kind of look at the dates, because we need to be having it coming back, well, a stop date, sort of maybe a couple of weeks before that board, whichever board it is we're looking at, so that there's time for the reports to be written. And Harriet will maybe just confirm the.
Yeah, I would just like to clarify as well, if the decision is that the convener is to be consulted on future applications, it's not actually a requirement to have a time limit. It is, the convener does have the power to return it to the board.
I was suggesting. Yeah, no, I was suggesting that we have a time limit on it, not that it's in consultation with the convener, that officers are delegated to make the decisions until a certain date, and then it would need to come back to the board.
Okay, if that is what
that's clear.
If that's what you're,
that's what I'm suggesting.
Yeah. So there is obviously the opportunity that you either have consultation with the convener, and the convener can bring that back at any time, or if you're electing to put a time limit on, I think, correct me if I'm wrong, Ms. Black, I think you said the 30th of April board. Would that be correct next year?
There's either, I said that there's either 30th of April board or there's the 25th of June board. But knowing what planning is like, going for the 25th of June board would be more realistic.
Okay, so realistically, officers would need to know by the 4th of June 2025 in order to cite the applicant back. I would also like you, if you could please clarify that if there is a premises license received in that time, would you still like it? Would you like it returned to the board?
No. Or if a full license application comes in the meantime, then it has no need to come back to the board.
Okay, so you'd be looking for your motion would be that delegated powers are returned to officers until the date of the 4th of June, if and it will then be returned to the board if there's no premises license application received. However, if there's a premises license application received prior to that date, you're happy for the powers to still remain with officers. Would that be correct?
Yeah.
While that license is being
while the process is ongoing, because the whole purpose of the policy is to ensure that full license applications come through. Yeah.
Okay, thank you very much for that clarification.
That's okay. Mr. Crowson, Jeff.
I'll second that.
Seconding, thank you very much. Okay, is anybody else got any other thoughts or want to put forward an amendment? No. Okay, so I can take it that that is a unanimous decision then.
Yes.
Can you confirm?
Agreed.
Thank you.
Yes.
Super, thank you very much. Can I please therefore ask the Deputy Clerk to confirm the board's decision?
I'm going to try. I couldn't keep up with Harriet there. So we have a motion from yourself, Ms. Black, seconded by
Mr. Crowson.
Mr. Crowson, sorry.
Yeah.
To grant the applications before you today and to subject to the conditions as outlined in the report and recommended, subject to delegating to officers future applications up until the 4th of June, and thereafter to return to the board if no premises licence application is received. And this is the bit that I didn't catch what Harriet said. If the premises licence was received, that maybe Harriet could just finish off.
Delegation comes,
right.
Remains with officers.
Yeah.
Delegation is to be returned to officers as of till the 4th of June 2025.
Yeah.
And if a premises licence application is submitted prior to that date, it's not to be returned to the board. Yeah. But if there's no premises licence, to be returned to the board.
Yeah.
Thank you. Thanks, Harriet.
Okay. So,
sorry, there was a second part of that motion, that future applications also have delegated authority if there was a premises licence to be submitted. I don't know if we captured that.
Yeah, you did cover that off, and also that they are subject to the local conditions as specified in the report.
Yeah, said that.
Yeah. Okay. Mr. Tong, is that decision clear to you?
Roughly, yes, pretty much. Pretty much.
We'll
get it done by the 4th of June, and with the support of the LSOs and working together and all that good stuff. So yes, no, I'm sure Ms. Cadini will keep me right.
Yeah, it will be confirmed to you in writing within 7 days as well.
Yeah,
so
that's
you'll
right.
have written confirmation.
That's absolutely
okay.
Fine. Thank you very much.
Thank you very much.
Cheers.
Okay. Thank you. I can confirm that this hearing is now concluded. So thanks for your interest in this business. And you may now leave. I'm sure you'll be very glad to leave the meeting at this point. Thank you very much. Okay, so how is everybody? Does anybody require a comfort break at this point? Because we've been going a while again. Or do you want to keep on?
Short break, please.
Short break. Okay, is 5 minutes sufficient? Just over 5 minutes if we come back at 4:05? Okay?
Yep.
Yeah, happy? Okay, we'll reconvene. If you can make sure that the live stream and the recording are stopped, please.